It's working now.
So that being said, do we need to do anything? Just for the, I mean, for the matter of formalizing it for John's sake, do we need a, I don't know.
If I can get- I guess if I get consent-
Short-term rental as a best practice.
Just a consensus that that's what you want to do. If that's what you want to do, I think that's all I would need. Well, a conditional use is going to be, because they're gonna, it's going, all these are gonna go before the Board of Adjustments. So what's gonna happen is there'll be two letters sent out. There's only 2 VRBOs that I'm aware of. And they'll be given the information to let them know that they have to apply for conditional use for their VRBO or their, whatever you want to call that, but it's gonna be a, maybe listed as a bed and breakfast. It's the way it's defined.
In theory, based on our ordinance, if they're turning a house into a short-term rental, therefore, bed and
That's a
breakfast,
change in use.
change in use, but the object that we're trying to regulate is for it to be a dwelling, there's supposed to be 1.5 parking place per bedroom, 1.5 per bedroom,
That's permanent.
but still. So we're gonna call them in and say, you've got to have 1 parking place. They should already have 1.5.
Well, that may be something that we'll have to look into.
You're not taking care of the boats.
Well,
6 guys in it with 3 boats.
3 votes and 3 drives.
Which, that's not overloading the house, but it's definitely overloading.
that's a police matter for if you're drunk and acting out outside. That's a police matter.
Oh, but it's- But
Right. I'm not hearing aids in today. Sorry. Gotcha.
But even in the conditional use, can we define in the conditional use that, that on-street parking is not allowed?
We can make a statement.
Yeah. The point being is that way,
Again, another reason.
that way. To miss it, they gotta stay in the yard.
Okay, so would we want to set it up where they don't have to come to additional use? Just they get this data, what does that do?
Well, it's always been a conditional use. We've already done 2 or 3 of them as it is. We've done 1 across the street over here. It's conditional use.
We have probably over.
It's JSK.
Conditional use, we probably overused conditional, use. But in this particular situation, we're talking about. Yeah, that's gonna be. It isn't. Situation. Where it's. And
You might-
Yep.
Considering they have-
one and a half per. A long time.
Well, the change of use will actually, well, yeah, that's what you're saying.
He's talking about, we already require 1.5. Yeah.
But whatever's there, it's like,
No.
a lot of times they'll change and add bedrooms because they've closed in a garage or something like that we know nothing about. Because they don't have to go through us for that.
How much effort would it be to change the wording? To clarify this.
Petition.
Easier.
We just, it's simple enough.
Just change it.
Explain the wording. Oh, I know, but you just tell us that we look at them both as the same. That's all.
But I'm with Darren. It seemed to me like it'd be best in our definition, we put the bed and breakfast, that we just, in parentheses, short-term rental, add those words in there so that John has black and white to say, we treat these the same, rather than somebody coming in and saying, well, the ordinance didn't say anything about what I'm doing. I'm not doing bed and breakfast. I'm just doing rent my house by VRBO.
That or just add the word short-term rental and say C, bed and breakfast.
Let me read this one more time.
It's gonna be a language check.
When in which one or more, but not more than 5 guest rooms are used to provide or offer private accommodations or transient, that's the ambiguous word. Transient guests for compensation. I don't, anything that doesn't fall within that definition.
I know what you're saying. It's just a simple language, in the schedule of uses, short-term rental, C, bed and breakfast. I think that would meet everything, that way there's no doubt in someone's mind if they're trying to look for it. I know it's easy for us to, because we deal with this, but if someone downloads it and they're looking for short-term rental, they may never find it. They may never even consider it to be something like a bed and breakfast. So it's kind of see that it's more for to me, it's more for the public. And when they look at it than it is for us. Because we're trying to make it whether it's convenient for the public to download this stuff. And that's probably the only.
Maybe for that
Which is
purpose.
actually the same thing. That's correct. So 5 is a bed and breakfast, 5 and down, so 6 and up. Is motel.
Nine is.
But we're not gonna regulate that any differently than we would.
But
Right.
there's something that somebody had a larger.
Yes. So they'll have to make application.
They would be a boutique hotel.
Motel is simply a building. What, Darren, what is the confusion? Is there something that's not clear for you? Adding words, is there some, what words would you want to add in order to address what?
That's the person that's your reference.
Part of it, part of understanding the words.
To your point, Renee, the definition that we've got would
Covers it all.
but what if in the schedule of uses, we had under short-term rentals, just CB and B? And we had, the city handles a short, just the same way with B and B, and that's covered by the schedule of uses. And that way, there's a question comes up, it's covered that way.
I think for the public, it's easier because it's easier to find.
Well, I'll show you how little I've used any of them. I have stayed at bed and breakfast. Yes, I've never stayed at one of those. mistaken. Part of the B&B, that's- So, yeah, that's easy to just say CB&B.
Gatlinburg, it's air, bed and bears.
You want to recognize?
So, just on clarification, what's the process we have to go through to add that?
Next amendment. Public hearing.
Public hearing. Trying to advertise it. Have a public hearing. Then nobody will show up.
Aaron can pantomime it.
Yeah, they might. And so.
It would be an ordinance amendment eventually, just to add the language, but that's what it is, yeah.
There's no doubt there's some hoops to go through. But I think this is going to be a common issue in Tennessee. Because we're supposed to play. It's exactly what Joel, and it's exactly the problem that Joel saw is exactly what I see to happen, because got folks that's gonna come in, many of the folks that's gonna come in are gonna come in for fishing, and they're gonna have a boat and a trailer. So you just use two parking places for it.
I'm gonna proceed on if it's all right with the commission. When someone comes in or we're talking about something like this, I'm just gonna say we're handling it as a bed and breakfast. If, until this text amendment's done.
Yeah.
Okay.
Yeah.
All right. And then move forward with that process. Good.
Okay with that. Short-term rental, that's those are the words.
That would, because that would cover the brand names. It's actually VRBO, that's actually a brand.
Yeah.
Yeah, Airbnb, that's a brand name.
Everybody get their, I'm sorry, I'm jumping ahead.
Go ahead.
Everyone get their copy of the comprehensive plan. I sent that out this past week. You should have received a copy of it. Again, it's one of those things that we just need to look it over, see if there's things that need to update or not. Know of any changes, think of any changes that would require us to go back and address that. If we do, then I will probably start to gather up someone to go through this process with us.
Should we, just for the purpose of, I guess, formalize, the whole goals and objectives are the critical piece of that, should we maybe next month just pull out that goals and objectives and go through those, everybody?
Sure.
Again?
You've got them, if you'll review them, then we'll
Yeah.
just, put that on the agenda, of course, be a regular meeting, so it doesn't, we can just talk about it, whether it's on the agenda or not. Yes. Your goals and objectives. All it is everybody's gonna go in October. Missed any other opportunities they've got unless they want to cross the state. I don't really want to pay for that. We got something going right here in our backyard in Princeton in October. And I'm probably gonna, as soon as they'll allow us to schedule everybody, I'm gonna schedule everybody for that.
What date was that?
Thursday. The only other thing we had close to us was in Elizabethtown, and that was a little bit earlier this, well, end of March, wasn't it? First April, okay. And everybody missed that one. So,
And you were saying that the 18th and 19th.
no, just the 18th, it's one day, just one day.
Good, because 3D Nationals is in Foley the 5th and the 7th. So I'm gonna have to.
That's what I have.
Good, all right.
It goes the 18th.
Anything else?
Yeah. Hesitant to- It's not for you guys to discuss. This is important for me. This is a legal issue that just frustrates the heck out of me.
Yeah.
I just want to tell you guys sort of where I am in the thought process, because it seriously affects your decisions. You probably are aware, you probably remember me reading, look at variances. When we look at the issue of variance, statute, at the bottom of the statute, there is a subparagraph that says, if the need for the variance arises from a willful violation, you are prohibited from granting the variance. Okay?
So we're always better to ask forgiveness information for that situation.
That's right.
We haven't done it, and now we need to make it right.
Legislature says, because if it was a willful violation, now, the words willful violation are not defined in that chapter. As you read law, many times, for the specific purposes of a given section of law, they will give you a definition section for construing the provisions of that section, that chapter. That's not a phrase that's defined for variances. It just simply says willful violation. Okay. In general jurisprudence, not in zoning, not variances, but just in general jurisprudence, that term is likely to be construed as not meaning knowingly, but simply was the action willful? Did you accidentally build a porch on your house?
Or it just happened.
Right,
Hey,
it just happened. And that, like I say, under general rules of jurisprudence, under many issues, that would be construed as, oh, if you intentionally did whatever that it is that violates the setback that requires the variance, then the Board of Adjustment is prohibited from that. For the little small town of Talbot City,
I think we've set a precedence though, already.
wait a minute, let me logically walk you through this. Okay?
Wait a minute. We're talking legal and you're playing logic? Tell me you're not doing this.
Logically. Take you through my thought process. Now, there always, one other piece of the puzzle is, in the past, we, Board of Adjustment, you guys, construed those words in that statute as a pair of words rather than one, as willfully violated, meaning that the violation was willful, not the action. And we have so construed that statute many times In 2017, there was a case, and I almost want to say it's Bowling Green.
It is, Warren County.
There was a case of Bowling Green that was a non-published case. Now, when a court of appeals or the Supreme Court don't want this, when it doesn't rise to the level of earth shattering, they don't really want people to rely on it for precedent, then they will not publish that opinion. It's published, it's right there, just read it. But it's a non-published opinion. The dicta, which is the non-dispositive language in a court, in a case, in an appellate case. That court, in a non-published opinion, just generally talking about the law. It was not dispositive of the issue before them, but they were just generally talking about the law. They recited, confirmed that a willful violation is what I told you first. That if you do it intentionally, whether you knew it was a violation or not, about a variance cannot be achieved. Okay? It's not really binding on us because it's a non-published case. But it's there.
The facts of the case were that the individual had already obtained a zoning compliance and conditional use for a property that they owned right beside the property that they committed the violation on. So it was they willfully knew that they were moving on and didn't want to wait because they had received one for the other property, but not one for this property that they actually built on and violated. And that was part of the reason. Again, it was not that the person was not aware, the person was aware. Even in this case, that person was aware of what they were doing.
It was a willful violation.
That's correct. It was a willful violation. That's the other strange part about it, that it was a willful violation.
All the municipal attorneys that are all a part of lists. It's just a conversation. It's an ongoing conversation where we all ask one another, have you ever heard anything like this before? What do you think? Send it out on the list, sir. I also called a couple of prosecutors and said, what do you think? All of the attorneys that I talked to about this situation agree in that particular context, making somebody tear something down so that you can approve it and then rebuild it is not a result you want. It's a ridiculous act. And I heard two strategies for how to avoid that outcome. One was that the prosecutorial team, which starts with the officer that gave you the ticket when you ran the stop sign, all the way through the judge. At each step of the prosecution, the prosecutors determine whether or not they're going to pursue this. Anybody that runs a stop sign doesn't get a ticket. They don't even get stopped. Some of them get stopped but don't get a ticket. Some of them stop but get a warning. Some of them stop but get a ticket, but then the prosecutor decides, oh, he doesn't prosecute. Because it just doesn't rise to that level of significance. Or they got a bad case. Or it's a case that no jury in the world would ever convict. So that's one strategy for how to deal with this. Another strategy was, that's a non-published case. Your own precedent is to construe that statutory phrase this way. If nobody challenges it, if nobody appeals that construction, okay, it's not appealed. There's never a court going to rule. My inclination right now is to advise us to go back that the way we have construed that statute in the past, though there is some at least picked up in other cases to indicate maybe that's not the proper construction, but it's certainly a logical construction. And the other alternative leaves you with a seemingly, to me, nonsensical, if not offensive, result in many situations. Because when you get a situation that nobody in the world would ever complain about, yes, it's a violation, but they only went 6 inches over, and it was with a structure that's not offensive in any way to anybody. And you're gonna make them tear the whole thing down, then you're gonna sign the bottom line and let them build it. I don't think that's a rational construction of those words under the circumstances. Now, under some circumstances, yes. Sure, if somebody just thumbs their nose at you and says, I don't care what your regulation is, I'm doing it anyway. Okay, well, that's kind of a willful violation. Or if it's with tortious intent, you know, with willful neglect. I didn't check, I didn't know what it was, it's because I didn't learn it. I didn't ask.
As I speculated.
Yeah, yeah. I didn't know that that was. And so my inclination is, if it gets appealed, if we make a ruling and we get appealed, and the Court of Appeals says we're wrong, then okay, we're wrong. Then from that point forward, we'll use whatever test the Court of Appeals tells us to use. But until then, I think the rational reason was it a violation, or a violation so negligently determined that it wasn't truly, it wasn't with knowledge or should have known. So I've struggled with that now for actually quite some time. And I thought, it's just going to lay it out. That's where I think we are. We've got a couple of those issues now. We've got a couple of those issues that are going to be coming for the Board of Adjustment for all. I think that's the way we ought to approach it. Practically speaking, that's the way every municipality that I can find treats it. For one reason or another, they're not going to truly innocently violated a setback, tear down whatever it was, their house, in order to get a setback. Unless it's one that is offensive, then they wouldn't issue a variance. Is there a risk? Sure.
It would be an unusual case for it to be argued that the person paid to take it to court.
Unless it was one of those that somebody violated the setback, it truly was offensive. It was blocking side of line of sight on the road, or it was something offensive and almost intentionally offensive. And so then we and then they would say, wait a minute, the precedent says so aggressive. My response would be being denied the answer. Because it's so I'm not without a position, but it does take from me the ability to say blanket. No, it was a willful violation, so you got to do it. So maybe I just need somebody else to for the issue that comes around from time to time.
But I think that these things, I agree, just stay consistent with what you've been doing.
That's gonna save all the risk in the long run anyway.
And if that was a published case, I wouldn't really have any choice.
Yeah.
That's the published law. Don't have to do it.
Say if someone willfully violated something like that, they were.
Well, no, he just said that. Right?
Unless
Yeah.
this violation didn't, you know, to grant a variance, you gotta meet all these standards, and it is, that it basically
Well, I see.
that would work a hardship on the owner if he didn't have, if he wasn't allowed to violate, and it doesn't create an undue hardship on adjoining properties, doesn't violate, it doesn't, obstruct line of sight.
Yeah, like I said, it's not being denied because of a willful violation. It's being denied because it wasn't gonna be granted anyway because of some other reason. So, but yeah, so it's not necessarily that you set yourself in the corner, you haven't.
But you're taking some of the teeth. You pull some of your teeth. There's no easy, clear answer. And, you know, it can be argued that there's other cases that say willful means, no means intentional. Okay. There is such law out there, but they're not directly on point. Even the case that I just recited out of Bowling Green is not directly on point because the facts are unique and that was not the basis of the ruling in that case. It was just general discussion. So I just wanted to lay it out there. Okay, that's all.
Most cities don't have sharp we sleep easy. You're
And I sleep it all.
We know.
I'm gonna say. Greg said it's-
That's why I have a grimace on my face and hope it's coming.
Anything else? Motion we adjourn. Motion by Brad, second.
Second.
Second by Joe, all in favor, say aye.